Hi, this is David Demergent for Legal Update for February 2024. I apologize for the absence that I've had over the past couple of months. Unfortunately, it's a very busy trial calendar. Some very important cases have come out since then, and I think it's important for us to review some of them. One in particular, Strickland versus Nevada County. Case came out in June of 2023 from the Ninth Circuit Court of Appeals. Interesting case involving replica guns. Now, there'll be two other cases I'm going to mention in this that the court cites to, and I think it's important to discern the differences in the fact pattern on each one. In Strickland versus Nevada County, we have an individual who has a history with law enforcement. They knew him to be homeless and to have mental illness issues. In fact, he had just recently been taken in by the deputies for a mental evaluation in which he was released a couple of days later. Now, unfortunately, there was an encounter between this individual and the deputies, resulting in his death when the deputies had to shoot him because he had what appeared to be a firearm with him. I'll go through the fact pattern very in detail regarding what did occur. However, the holding of the court was, though the plaintiff was carrying a replica firearm, the officers, based on the totality of the circumstances, after giving him multiple warnings to drop the gun, the officers were objectively reasonable in shooting him when he pointed the gun at them. Here's our fact pattern. Plaintiff had just been released from custody for an emergency mental eval and was released after a couple of days. He was known to local law enforcement. He had a history of prior contacts with them involving mental illness issues, also homeless issues. There was a call that came into dispatch saying that an individual was walking down the street with a shotgun slung over his shoulders. The deputies responded to the 911 call, located the individual who they recognized as Mr. Strickland, who they had prior encounters with. He was known to have mental illness to them. They knew that if they possibly were going to communicate with him, he probably would not be able to understand their commands because of his mental illness issue. Prior to making contact, the deputies did not contact their supervisor, nor did they ask for a crisis intervention negotiator, nor did they ask for additional resources. Those are issues that the court did raise because they were concerned that the situation was going to develop into a deadly situation without using all the other available resources, which is an issue that the Ninth Circuit constantly raises. However, this case is a little bit different. The entire encounter from the deputies arriving to the application of deadly force was about 3 minutes. The deputies during that time period attempted to de-escalate and attempted not to use the application of deadly force in approaching the individual. There were a number of commands given to him to drop the rifle. His response was, "It's not real. It's a BB rifle." He slapped the side of the gun. It sounded like plastic to the deputies. In fact, he pointed out to the deputies that there's an orange tip on it. The deputies' response were, "We're not sure it's a BB gun. We don't know if it is fake. We don't know if you painted the orange tip on. Just drop the gun. We're not here to kill you." Again, the court pointed out the deputies failed to contact their supervisor, request for additional assistance, request for a crisis intervention officer, request for a professional negotiator, all the other additional resources that the court has been focusing on for the past several years regarding de-escalation. One deputy, and this I think is the turning point, at least as to why the court ruled the way they did, saying that it was objective reasonable force. One deputy requested cover deputies to go in and attempt to taser the individual. And again, this took over a 3-minute period. Multiple commands: drop the gun, drop the gun. Mr. Strickland, of course, wasn't complying with it. At no point during that time period up to this taser application did Mr. Strickland point the gun in their direction. The gun remained away from the barrel, remained away from the deputies, or not pointed in their direction. The deputy then makes this approach, which I think was very brave of him to do, because in light of the fact that if it was a real rifle, we could have had a dead deputy. Anyway, he attempts to deploy the taser. The taser does not work. Unfortunately, Mr. Strickland, in response to that, raises the rifle up, points it in the direction of the deputies, and multiple deputies respond accordingly with multiple shots, hitting Mr. Strickland, who then dies at scene. The court's analysis of the application of force is, as we know, the basic factors that we've seen from Graham versus Connor, plus the additional factors that the Ninth Circuit has pointed out before. First one is, look at the type and the amount of force used, in this case, deadly force. 2, the severity of the crime at issue. Mr. Strickland's walking in a residential neighborhood with a rifle slung over his shoulder, unknown as to what his intent and purposes are. He's mentally unstable. it's pretty severe, I would say, as to what they're responding to. The third issue is, did the suspect pose an immediate threat to the deputies and to others? And by the way, the court considers this factor probably the premier or number one factor to be looking at, the immediate threat to deputies and to others. The fourth issue was the suspect actively resisting or trying to evade arrest or resist arrest? Fifth was availability of less intrusive alternatives to the application of deadly force. Number 6 was whether proper warnings given. Number 7, was it apparent that suspect was emotionally disturbed? Interesting analysis. We knew he was emotionally disturbed. The deputies knew he was emotionally disturbed. Multiple warnings were given. And the availability of less intrusive alternatives to force. I think the application of the taser, though very risky for the deputies, was one of the ways that they were trying to show that they were attempting to use some other method of force aside from deadly force. And again, the court focused on the immediate threat to the deputies. There was no immediate threat to the deputies until this rifle came pointing up in the direction, and at that point, the application of deadly force occurred. The court stressed that it was a dynamic situation. In fact, the court made a very interesting analysis regarding the spectrum of force. Spectrum of force was on one end, the extreme point, I guess the most extreme is the pointing of a gun at deputies, is the creation of immediate threat by way of movement, threat, or gesture, thus making it apparent that there is an immediate threat. At the other end of the spectrum, the court said, it's no use of force is tolerated to seize an unarmed, non-dangerous suspect by shooting him without probable cause of threat or serious physical harm. So again, two very extreme situations. In this situation, it was reasonable for the officers to deduce or at least assume that this was an actual rifle being pointed in the direction. The analysis, though, that they made with these other two cases, which are cases I strongly recommend you read, is Nicholson versus the City of Los Angeles and the Estate of Lopez versus Gelhaus. In Nicholson, the entire encounter between the officer observing what he believes is a pistol in an individual's hands and to the shooting of 3 rounds at the individual, hopefully attending to hit the individual with the pistol, is about 20 seconds. The court said that the application of force in Nicholson was excessive because of the officer's failure to deliberate before taking action. In that situation, we had 2 LAPD officers on the way to court in an unmarked unit driving in an area, coming up to the court. He looks down the alleyway and sees 4 individuals standing, talking to each other. One has what he appears to be a pistol in his hand. When he yells to his partner, gun, 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 and says nothing more. His partner jams on the brakes. The officer gets out of the car, runs up. According to the officer, he identifies himself and says, drop the gun. The individual holding the gun, they look in that direction. At that point, the officer fires 3 rounds. The 3 rounds miss the individual with the gun and hits somebody else in the back. The person doesn't die, and then the detention occurs. In that case, qualified immunity was given to the officer, but the court had a problem with the application, saying that he did not deliberate enough, he didn't communicate a plan to his partner, he didn't advise anybody as to what he was doing, and sort of took action within 20 seconds and fired the rounds. From the officer's perspective, he thought that this was an ongoing robbery or that the individual was about to shoot somebody. It turns out it was 4 friends. Before they went into school that day, they usually meet up in this alleyway and allegedly dance and sing rap songs to each other. That was their theory as to why they were standing there. The officer perceived differently. Again, the court had a problem with the fact that he did not deliberate. There was no communication of a plan to his partner, no radio communication, nothing. He just ran up the alley, failed to take cover. And by the way, they pointed out that LAPD policy dictated other course of conduct that the officer should have followed. Thus, he was in violation of policy. So the court said it was excessive force. The other interesting case, and a very tragic case, is the Estate of Lopez versus Gelhaus. Again, the court found excessive force. Very interesting set of facts on this one. And again, another replica gun. This thing with replica guns is just, it makes it very tragic for everybody involved. Officers are driving in an area that is a high crime gang area with a lot of violence. Officer observes an individual walking down the street at about 3 o'clock in the afternoon and sees an individual walking down with an AK-47, holding it by the pistol grip in his left hand. He tells his partner, what's going on. He also radio broadcasts that they have an emergency clearance involving an individual with a gun. I think he just puts out an emergency clearance. The partner activates the lights plus the chirping sound of his police car. They do the approach on the individual. And interesting, the officer prior to this date had also confiscated an AK-47 literally a mile from that location. He had prior dealings with people with guns in that area. When he sees the individual walking down the street, he sees again what he believes is an AK-47. There is no orange tip on this gun, and he sees the individual holding it. The car is stopped. The officer gets out. He then, from the time of the shooting to the time of the stopping the car is about 20 seconds. He yells, "Drop the gun." The individual with the gun begins the turn. He pauses a few seconds and then turns and faces the deputy. At that point, the one officer says, well, the gun was pointed in his direction. The other one says he's not sure, but they don't both say they don't see a figure on the trigger or they're not able to. At that point, the officer fires 8 rounds, killing the individual. Turned out it was a 13-year-old kid who had, or somebody had removed off the orange tip of a replica AK-47, which was a BB gun. Again, a tragedy in every regard. The court held it was excessive force, and the grounds was that the barrel was not pointed at the deputy, the suspect's finger was not on the trigger, and that he did not pose an immediate threat. Again, this is the court's reasoning. That's the facts. They, at that point, this is again a qualified immunity, or actually it's a motion for summary judgment prior to trial. They determined there was no immediate threat to the officers or to anybody else. Even though the individual was walking in an area where there were 3 schools, the deputy testified, or at least during his deposition, stated that he knew that an AK-47 round would easily go through his doors, so that he had no cover or concealment. And he was concerned for the safety of the individuals that were in the school, and that's why he took the action he did. The court said excessive force. There would need to be more deliberation, better tactics, according to the court. It's an interesting analysis of replica guns. This most recent decision coming from Nevada County is interesting because it has a different conclusion, and there seems to be the immediacy and the attempts by the deputies to use another alternative aside from deadly force, which seems to have the court sway to objective reasonable. Now, tactically, each one of us are going to have a different conclusion as to the best tactics of dealing with somebody with possibly a gun. Again, you have to take all this into consideration and consider your tactics. We'll see what happens for 2024. There's more cases that are coming down the pipe regarding applications of force, deadly force by law enforcement. I'll keep you posted to whatever I hear and get it out to you as soon as possible. In the meantime, be prepared and be safe. This is David Demerjen for Legal Update.